Hello, sir. You are not audible.
I am audible. Acha, are you able to listen to me? I was not speaking at all.
Okay, okay, sir. Okay.
We have not started yet. Yeah, yeah. Please
Yeah,
go.
that's what I thought. Yes,
Yeah, okay, sir.
that's
We'll be starting in 1 minute, sir.
no issue, no issue.
Yeah,
That's what
okay.
I told you. Take your time and start whenever you
Yeah,
want. Now I'm
yeah,
in ready
sure, sir.
mode.
Okay.
Thank you.
Okay, Rachit, are you there? Rachit?
Yes, sir. Yes,
Yeah,
sir.
please start. Yeah. So this we are starting. Rachit,
Okay.
over to you.
Okay. So am I audible and visible?
Yeah, from my side you are
Yes.
audible.
Okay. A very warm good evening to one and all, and a very happy World Environment Day to all the participants, and especially to our resource person, Dr. Sudhir Kochar, who is a prominent voice when it comes to environment and its protection. Sir is a distinguished agricultural scientist with over 45 years of experience in research, coordination, training, and policy nationally and internationally. Sir holds a PhD in plant breeding from PAU and has held significant roles, including Assistant Director General IPR at ICAR and National Coordinator for National Agricultural Innovation Project, amongst many others. Sir has contributed to key legislative developments such as Protection of Plant Varieties and Farmers' Rights Bill and Biodiversity Bill, and provided international consultancy on intellectual property rights and policy. His work has led to numerous patents, publication, and the establishment of IPR frameworks in agricultural research. He has also served as a consultant to the Republic of Mauritius and participated in global agricultural policy forums. I am sure that the participants will greatly benefit from this session. It is our honor to have you, sir. Over to you.
Thank you very much. First of all, I extend my heartfelt thanks to the organizers and also the mediators, Kalpesh and Pankaj. And it's an honor to be among the faculty. I'm not a teacher, particularly law teacher, but I'm an IPR expert into the field from since 1995, and it's my honor to be on the cutting edge because ours is a techno-legal field, and in this techno-legal field, both sides are equally important to us. It's very hard to connect each other and remain connected too, but it's an endeavor, and I'm always happy whenever interacting in such fora. So whenever you feel that there is a need for any discussion in between the session, please feel free, and I can interact on that there and then itself. So I start with that. We have a 4-volume history of agriculture in India, authored by none else than the Doctorate of Evolution Botany, Professor M.S. Randhawa, who was a retired ICS and Administrator of Chandigarh and also Vice Chancellor of PAU and also Director General of ICAR. In the very first volume, on the very first line of its preface, it says, agriculture is the source of perpetual creation on which civilization depends. When this is said, nothing more is left to be said. And having said so, let me recapitulate with all of you that agricultural and the first cultural revolutions in this civilization These developed symbiotically, simultaneously, because it was from nomads that the settled agriculture began. It was the beginning of the realization of need that some improvements in plants were done from time to time, which were domesticated by humans. Can you hear me?
Yes, sir, you're
Okay.
audible.
Okay. Then further to that, I mean, it was found important for your living, your clothing, and your shelter, but it was also the ethical eccentricity, or you can say the love for flowers that gave rise to formal plant breeding. So it emerged in the year 1790, and Thomas Fairchild was the first who made crosses between the two flowers, incarnation and sweet williams, which gave rise to the uh, Fairchild's mule. And from there, then the seed company came, which was known as Wilmorin Seed Company in just a decade from that development. And that's how the business in plant varieties itself came to the fore. So plant variety in development context, of course, it's an industrial product, and there is innovation involved. There is inventive step involved in developing new varieties, in evolving new varieties, that we take it at par with other fields where protection for intellectual property is needed to be granted for all trade related aspects of IPR. And not only that, it is also a necessity in the sense that there is a perpetual need of having incremental or radical changes in the genetic makeup of the plants to make new plant varieties from time to time so that they can meet the local requirements, they can meet the requirements for healthiness, they can meet the requirements for specific quality, yield, adaptability, fitness, and everything. So these essentially cater to the meeting the Sustainable Development Goals, particularly SDG 2 in particular. This, in addition to SDG 2, the environment and also climate change factors. So, because we are dealing with IPR in today's lecture, and IPR in its absolute value, like these published papers, has no say in academia or in research world unless it is linked to trade related aspects. So doing business in plant varieties is a, so to say, a prerequisite where choice of portfolio of crops and varieties in terms of, as I told you already, adaptability, fitness, productivity, etc., that matters. So a company or an organization dealing with plant varieties and seed business, they need to have a dynamic backup of the germplasm for developing new varieties. And in addition to that, they have to ensure that there is investment, rather inadequate investment in terms of the financial resources, whether they're own or raised, or you can say direct investments, as well as infrastructure, which is includes the labs, sheds, threshing floors, etc., and field for growing the crops, and capacity to hold those things, store those things, as well as trained human resource to work on that. So these everything subsist in the part of that intellectual property, because intellectual property is nothing else but the interplay of your knack of business, or you can say sense of business, as well as your agility to do business, where a research is involved, implicit R&D is involved, testing is involved, validation is involved. Your you can say near perfected entry into the value chains is involved in business, not only at the local level, but also at the regional and global levels. Then coping with the regulatory environment for investment friendly compliances of government and client policies. It's not only government policies, but also the policies of your potential licensees or your potential donor, you can say inventors, from where you have to in license certain materials. Then efficient tackling of legal, regulatory, and administrative matters and things like that. Then meeting the market pull and consumer demand, particularly in the present era. The context is about, you can say, delving into the food system transformation, which is gradually happening, silently happening all over the globe in climate change context, because it is at that time you never know which crop will succeed, which crop will fail, and which type of variety is needed. But food systems based on all that variety or array of the potentially food producing crops and varieties, it is important to learn on those food systems. And then, of course, there is always a competitive edge, which, as per demand, is required to go in favor of the developed, in favor of the rich. But then you have to sustain everything on your own, also within your own system, so that the masses are also equally benefited from that. Then technology push for plant varieties as industrial property. If I have to give you an insight into that at the advanced level, you just see it is the era of the 18th century and some part of the 19th century in which there are some patents, there are early patents rather in agriculture inventions, like for drilling of seed, like for plowing of land, like that for reaping the crop and the harvest the grains, like for spinning the cotton, gin and jenny. With these type of patents in the field, naturally the demand of responsive varieties arose at that point in time itself. So it's a gradual process. On the advanced side, this is happening. And on the developing side, the subsistence of farmers with the materials available in farm as in farm as or in situ as land races or folk varieties, and their indulging into that to improve their qualities, improve their local adaptability, and all that simultaneously mattered. So that pushed plant variety business. As I told you, the birth of plant breeding was in 1749, and the emergence of the seed company was there. And of course, all this culminated into the need for intellectual property protection, as in any other industrial field. The Paris Convention was there in 1883. It's not that things were not happening prior to it. So business as usual, or you can say prior art, before the birth of plant breeding. You see, this is a standard old English language, the spellings and the slang in the writing. It is an 1627, you can say, published in that year, a piece of information by Francis Bacon, which say, and we make by art, because plant breeding is nothing else but art and science of altering the heredity, the inheritance factors of plants to make them befitting for the immediate local and global demands. In the same orchard, we make by art in the same orchard and gardens, trees and flowers to come earlier or later. So the, you can say, maturity dates matter, than their seasons and to come up and bear more speedily than their natural course they do. We make them also by art greater much than their nature, and their fruit greater and sweeter and differing taste, smell, color, and figure from their nature. Also, we make them differ in color, shape, activity, many ways. We find means to make commixtures and populations of diverse kinds. Kind is for crop. In the Seed Act 1966, if you see the word kind, it means crop, and then their varieties, which have produced many new kinds and then not barren as the general opinion is. Neither do we this by chance, but we know beforehand of what matter and commixtures, what kind of those creatures will arise. So that means art and science part is being described in a colloquial way in the early era. But it's, you see how beautifully it has been recorded. So it's a question of recording the evidence at a particular point in time that matters. And this is perhaps one of the oldest pieces that I could bring for you for the purpose of reference. And then with rising market pull and the protection of plant varieties, the demand further grew. Like in 1887, it was in 1889 that Paris Convention came. So it is almost at the same time around that the US Association of Nurseries, Seeds and Seedlings, they demanded for patent right protection and trademark protection of their seeds and seedlings, because when they are exporting their materials into Europe, if it is legally protected, then they will be able to handle infringement cases more effectively in the local courts of law, and of course within the jurisdiction as well. So it was in 1926 that Luther Burbank, a horticulturist who had served for nearly 55 years of his career as horticulturist, means served means worked himself on his own also, and had his big company. So, and had generated some more than 800 different varieties of different crops, that the question of his inheritors and successors and protection of the materials that belonged to were developed by him and belonged to his company, that arose. And it was at that time that the US Congress thought of bringing an act which was Plant Patent Act. So demand rose in 87, but by 1930 the Plant Patent Act came. Not only that, from on the basis of this act, the application of that act, as many as 16 patents were granted to the materials developed by the same person, Luther Burbank, and some of his materials, like Burbank potato, which was, of course, later on improved to make it russet Burbank potato, means it was made disease-free, is still being used in McDonald's for the making French fries and like that. So, and then breakfast prunes and many other varieties are there. So next to that, what this Plant Patent Act, it was derived not from on its own, not as an independent statute, but from within the statute of existing Patents Act, a section was carved out to make it as a Plant Patent Act and passed by the US Congress. So that was for asexually propagated plants only, the plants which are not cultivated by seeds, but by, you can say, buds, grafts, tubers, except for that potato, except for that some other tubers. So those exceptions were also there. And it reigns till now. More than 40,000 plant patents have been granted in USA based on this act. And Then up to 1960, there was a drought. I mean, there was no parallel development anywhere in the world. But by 1961, a first convention for the protection of new varieties of plants, UPOV is a French acronym for the same, that was there, and six countries, European countries, initially started with that convention. It was slightly altered in 1972. It had come into effect in 67, 68, and then the first UPO model was developed 1961-72. It was improved on as a 1978 model, to which India wanted to become member. Uh, by the time they had, you can say, tabled their bill in the parliament in 1999, because there was a timeline up to December 31st, 1999, that the countries who had their, you can say, instrument of accession or the corresponding statutes in place, they could have become member of UPO. It could not happen. India still is not a member, but a strong observer and technical contender and participant in the UPO Council meetings. Then it is operating in 79 countries, and the present statute from the UPO side is UPO 1991. Another development that happened was in 80s, that the FAO Council Resolution 8 by 83 that passed for the establishment of Commission on Plant Genetic Resources. And the same resolution also, you can say, allowed for the establishment of an international undertaking on plant genetic resources, which was a non-legally binding instrument. Of course, it was adopted by 111 countries only, but it was important, you can say, development. And in 1809, there were two revised agreed interpretations to the same international undertaking, which originally said that the genetic resources are common heritage of mankind, which should be freely available for research and further use. So, two additional interpretations were brought by way of resolutions 4 by 89 and 5 by 89, which said that the protection to plant varieties given by the UPO model of plant variety protection was in conformity with the undertaking, meeting the undertaking's objective, and hence should be recognized. And it was at that point in time that there were voices from the developing countries that the recognition to farmers should also parallelly be there, because they have also indulged themselves into, over the successive generations, in improving and refining the materials there and then in the field conditions. And the third resolution, that was 3 by 91, it said that even though it is a common heritage of mankind, the plant genetic resources, but access to those resources is a sovereign right of the countries. So it was 1 year prior to the signing of the CBD that this resolution had come under FAO banner, but since it was a non-legally binding agreement, uh, undertaking, and the you can say Convention on Biological Diversity was the first legal instrument in the area of biological diversity or biological resources use, that we say that for the first time sovereign rights on bioresources or genetic resources were recognized by the CBD. So now, second thing, as I told you, this 1887 concern of the Nurseries Association of Nurseries in US, that trademark protection is as important to the seed and seedling industry. and not all the varieties are protected by, you can say, plant variety protection certificates, titles, but at the same time, they are protected by making hybrid varieties of that, where reverse engineering was not possible in conventional plant breeding. Rather, it was time consuming and resources consuming or costly, and it was automatically discouraged. And that is why uh, those things like protection of undisclosed information were used as the assets which were there in trade, which were protected and you can say propagated as branded material of certain companies which developed their own goodwill in the market. This slide, particular slide, shows you the trademarks or you can say logos of some major seed companies of India. Of course, Monsanto is no more in the Indian business as such. They have withdrawn their business from India, and other are still in operation in the country. And then uh, that's what I told you, that since we talked of IUPGR, a non-legally binding instrument, there itself, following it, this issues of biological diversity, trade, and sui generis IPR on plant varieties emerged. It was in 1992 that CVD came, 1995 that TRIPS came, and the TRIPS Article 27 3B particularly gave way for the mandatory protection of plant varieties by all WTO member countries, with certain exceptions permissible under Article 27.2. And then the international treaty no, undertaking on plant genetic resources was revised after a 7 years long rigorous process of intergovernmental negotiations, first consolidation of text and then strict negotiations, that the issue of farmers' rights was brought as a, an international law on farmers' rights. And this is the only treaty, the ITPGRFA, that under Article 9 describes what are farmers' rights and what is international law on farmers' rights. And of course, second thing was that what will happen to the collections made in international gene banks, which were held in custody of FAO, which were collected and conserved under the CGIR gene banks and other international and national gene banks, who opt to put the same material under custody of FAO as a common heritage resource for the international community. And for that, a multilateral platform of exchange of germ plasm and benefit sharing mechanism was also developed under the ITPJRFA. So it is at that point in time in 2001 that India also passed their bill 1999 to make it an Act 2001, 53 of 2001, which is a sui generis PVP, which is first of its kind and unique in the world, that it takes care of the breeders' rights and farmers' rights simultaneously. And the transition period available to India to join this full stature of TRIPS agreement, that ended on 31st December 2004, so that by 1st January 2005, India entered into the product patent regime under the TRIPS agreement as well. So retrospecting the TRIPS standards vis-a-vis the PVP, you will see that the patents, the trademarks, the geographical indications, and of course, the plant varieties, which is also a part described in the patents, these can be directly applicable to the protection of plant varieties. And of course, as I told you, protection of undisclosed information as parents of hybrids, etc. It is there. It's not that the other three forms of uh, IPR are not applicable to the field of plant variety protection, but it is a limited use. And of course, just like copyright on the literature and other processes and industrial design, if I mean you have to glorify certain material compared to others, particularly it is a low volume, high value materials or seeds of varieties and other things, and then you can use it. And layout design of integrated circuits is where online business for you can say certain cut flowers, etc., of a very big scale, very big magnitude, is also happening at the world level, like Alsmeer market of the Holland and others, uh, where you can make India specific your own uh, uh, chip and circuit, and then run that business on that. Now, summarily coming to legal options for protecting plant varieties, it can be patents, which can be utility patents, or general patents, which is applicable to all countries, and plant patents to USA only, or PVP titles, which will give effect to plant breeders' rights on those protected varieties, PBR. So PVP and PBR go synonymous that way. And this system for UPOV is applicable to all UPOV member countries, which are 79 at present, including two regional organizations of EU and Africa, and which are having more number of countries simultaneously. Then sui generis PVP titles, which are permissible under UPOV, but which are borrowing some standards from the UPOV model and then operating it. And then regional title, I have also told. Geographical indication of goods. If you see geographical indications, three type categories: the natural goods, the manufactured goods, and agricultural goods. So in case of agricultural good, which happen to is essentially a plant variety based, or you can say local land race based material, there this can be protected under the GI law. And then there can be a dual protection, that some of the varieties protected under the GI are also protected under plant variety protection. And then, of course, branding for GI materials is possible, so that the authorized users, which are registered in register 2 of the GI Act, they can have their independent trademarks registered and can play their own way in the field of trade. Then trademark branding, it's very important, as I have already told you. So the basic framework came from UPO, and which the essential shows that essential criteria for the protection are somewhat like patents: the novelty, which is not now absolute novelty, unlike in case of patent systems. There is a grace period of 1 year for the field crops and 4 years to 6 years in case of the trees and vines, uh, for having their prior trials before filing the application, so that breeder be sure about the validation part of the variety for which she is seeking protection. And of course, distinctiveness, uniformity, and stability of those varieties to perform, which is based on certain test reports which have to be carried out. And then distinct nomenclature. The name in particular has to be unique. And this unique name uh, can be cross-checked by from the names of the already registered varieties anywhere in the world, whether it is uh, country is member to UPO or not, but they can use the UPO database and also the database of other national plant variety officers which are having their own sui generis systems, not a UPOV system. And if we compare it with the Indian system, you can add one more thing that there is a no to genetic use restriction technology, means terminator technology, means that if there is a particular gene segment in the plant material, varietal material, which allows for the full cycle of the crop, particularly grain to be produced, but that the grain cannot regrow to produce the next crop, means its germ is virtually killed. So India didn't allow protection on those type of varieties. Why? Because that will undermine our giving right to farmers to use and resow the farm saved seed. So that's why an affidavit of rupees 100 dimension is taken, and it is an essential criteria. So DUS test plans. For conducting the DUS trials, there have to be test guidelines. UPO have got standard models for many crops, and then countries, the national plant breeding offices, they can develop either adopt the UPO test guidelines or adopt their own. Also, for making the DUS trials, DUS testing, uh, the variety which is a candidate variety for seeking plant variety protection title, uh, it has to be compared against a set of reference varieties. And UPO have a system of reference varieties for particular crops, crop-wise. And in India, our act says the varieties of common knowledge. So our DUS trials have to be conducted against varieties of common knowledge, of course, which are standard materials, which are informed to the plant variety, uh, National Plant Variety Office, or you can say National Plant Variety Office can refer to the gene bank and provide seed of those materials for comparison with the candidate variety. Then in case of DUS testing and the test reports, in case of UPO member countries, the advantage is that the national plant variety offices of those countries, if they are willing so, the breeder who has earlier filed a PV of application in another country where DUS trials have already been held is willing to, or you can say ready to accept the test reports of that country, then the particular breeder can buy or purchase the test reports from that country and file in their application to the next country. So that means some cost saving and some mechanism is available. Whereas if it is a non-UPO sui generis system, then you cannot depend upon the DUS tests conducted elsewhere. You will have to get conducted your own trials as specified in the law or the subordinate law. Then there are some, you can say, balancing acts in this sui generis system where exemption for researchers and breeders is provided both under UPO as well as the national systems. And this is, you can say, essential exemptions. And but then there are optional exemptions also where UPO provides some farmers privilege in the sense that farmers can use resow some of the farm saved seed, subject to the provision in the national legislation of that respective UPO member country, respective UPO member country. And farmers' rights in our sui generis system, these are very well described, full chapter chapter 6 on farmers' rights, which details everything about it, which will come to it. Then there are legal considerations of sui generis protection because it has to be an IPR-like system so that there is a provision for, you can say, tackling the infringers and also penalty provisions and other considerations. So this is in nutshell the PVP system, and the Indian sui generis Act more or less has got all the hues of whatever I have explained there, except for that the farmers' rights are much more elaborate. These talk of also community rights. These also talk of benefit sharing. These also talk of gene fund compensation for underperformance. And then, of course, they consider farmers as cultivator, farmer as conserver, and also farmer as breeder, so that farmers varieties can also be registered as new varieties. Of course, the prior existing farmers varieties can be registered as extant varieties also, but then farmers variety registration is a, you can say, there is a laxity, there is some you can say different system, which is a softer system of accepting the application. And of course, the Act provides that the charging of fees from farmers and all the court fees, etc. This is not necessary. Then there is protection of innocent infringement and things like that. Then extant variety protection means varieties of common knowledge, varieties in public domain, which were there. These are also given protection so that there is a continuity of the prior activity in seed business based on the varieties which were generic, which were, you can say, otherwise in the public domain. But because of this act coming into place to give experience to the MSMEs, seed sector, so that can also be protected so that they learn to move into the value chain, seed value chain of protected varieties and things like that. This particular slide I have made out of the information that was available to me as a resource person to the Joint Parliamentary Committee while this act was being enacted. And you will see that these 6, 7 items that I have particularly given in detail are nothing else but those which have then been incorporated from the suggestions of public or the suggestion of states. Their opinion mattered to the JPC, and then that is how this act was gradually developed after revamping or reforming to a very great extent the original bill on PVP, this plant variety protection. Now, if you see, I mean, it's an advanced course, so a lot of thinking should go on the academic side also, as it was told on the very first day. So, as a nested design, if we view it, then Article 27(3)(b) is a part of the section on patents, which is a part of the 7 standards of IPR. So that means PVP is a type of IPR which is a patent like IPR. And that is where the implication is that a basic framework from country to country means WTO country for the application of plant variety protection law is may have to be similar to the patent law broadly, except for the permissible variation provided in country's law for fulfilling any domestic requirement needs and also in conformity with the TRIPS agreement, like the exceptions given in Article 27(2). The same thing as I told you earlier had happened in case of enactment of the Plant Patent Act of 1930, which was carved out of the existing Patent Act of the USA. So, some fundamentals of PVR, plant breeders' rights vis-a-vis patent law, particularly all things pre-examination, publication of application, inviting objections, giving fair opportunity to respond or be heard, and then examining test reports were the essential criteria, ruling out that the denomination of the new variety overlaps with the pre-existing varieties in global terms and other prescribed procedures, etc. There is a point that, of course, vetting that the variety meets the novelty criteria. There, I mean, the Indian system has got that the first sale or offer for sale voucher has to be produced and all, ascertaining the priority date, if so claimed. So, when I went for trainers training course in UPOV system of PVP, I found that one Thai lady, and she was official in the USPTO, US Patent and Trademark Office. She was chief of the, you can say, UPOV system, and in discussion, it happened that the USA is the only country which is having all the three system of protection. That is the UPOV system, plant protection for plant varieties, the plant patent system, as well as the utility patent. So, what do they do with the priority date? Is there any official notification, and what sort? And of course, there was a long exchange of emails, and she very beautifully clarified. And later on, also, I rechecked from the USPTO's website that there is a clear cut thing that the priority date will be across the three forms of protection. And similarly, UPO and non-UPO member countries, they have to see that the priority date in the on the reciprocal basis also it matters, has to be honored, because this is a standard requirement of the TRIPS agreement. Then, if you see, next thing is that the TRIPS is silent on balancing IPRs with equitable rights. Particularly, the trade law does not accommodate protecting farmers' rights and benefit sharing in the agreed sui generis PVP law. So, this is observation. Next is observation is that TRIPS is not in for strongest IP protection, that is patent type of protection for the biological advances. And here I read this statement: accept non-biological and microbiological processes for the production of plants and animals. Those of you who are from the biology or genetics background will understand that if there has to be a genetic engineering, it can be agrobacterium mediated transformation, or it can be gene gun mediated transformation. So gene gun is a non-biological invention, and the process for agrobacterium mediated transformation is a microbial biological mediated process. In both cases, the patent is a mandate. It is not that you can give it as an exclusion. So this is very, very significant to learn and understand between the lines. And as I've already told you, another feature of the sui generis system of protecting rights on varieties is that for effective enforcement, provision of legal action has to be made against any act of infringement. And remedies, these can be civil, these can be criminal, these can be administrative, these can be customs, and the things like that. And this all is provided. Then IPR protection to how many taxa means there are wild plants, there are cultivated plants, which plant variety you are talking of. So by default, it has to be for all varieties. But the UPOV system presently has got information gathered and systematically stored in digital mode for more than 2000 taxa. Taxa is genus and species, or what I told you, kinds in the Seeds Act 1966 means crops, whether these are cultivated crops or wild crops, you can say now in this context. So these are some of the elements of expressing that what is sui generis in the law of plant varieties. So that's what I have tried to explain. Of course, where you are not member of any multilateral platform, then you have to move on the basis of reciprocity. So principle of national treatment means without differentiation has to run. So jurisdiction, territorial, within national boundaries, grants by countries under their respective PPP legislation, and regional, it is by the community plant variety offices, like in EU and Africa, and it is under UPOV compatible community laws of the communities. And then the title is enforceable in all regional countries. And what happens is that some of the countries, they abide by the community PVP certificate, but at the same time they have got their own PV office, National Plant Variety Office, so that there is a more stringent enforcement if you have a title from their own PV office also. But like patents, there is no international grant of PVP. This is important. And for facilitation of PVP abroad, unlike PCT system, there is no multilateral platform for making international application for plant varieties. Of course, as I already told you, that the UPOV system gives limited opportunities to members for saving on costs, acceptance of DUA test reports of other UPOV members, etc. And then bilateral route is there, of course. Now, rights conferred and exceptions. The UPOV system has got a descript right of the breeder on the propagated material, harvested material, certain products from harvested material, and then any other provision which may be made by UPOV member country in its act, like other varieties, essentially derived varieties, etc. And then there are compulsory exceptions like the private use, non-commercial use, research exemption, breeders exemption, and optional exception for use of farm-saved seed, or you can say farmers exception. Whereas in case of the Indian sui generis system, it is section 28 majorly that will tell you the rights conferred on breeders. And of course, there are some other sections which will tell you which are the balancing rights also simultaneously defined in the same act, so that those have to be complied simultaneously for the purpose of benefit sharing, for the purpose of realization of farmers and community rights, and so on. And there was a lot of difficulty and problem from time to time, because first registrations started in 2007, and over the period of you can say some 12-13 years, these problems are being felt, and that is why the subordinate law was enlarged. The act came in 2001, the rules came in 2003, the regulations came in 2002, which had got the structures, forms, and fees, etc. There were two administrative notices on plant breeders' rights and modes of producing and selling seeds by the breeders, their authorized persons or agents and licensees, as well as a notice on the community rights, clarification on community rights, which was intended to remove difficulties. And of course, Section 92 rider was particularly applied on it, so that no one can determine the, you can say, legal aspects of the use of varieties on which entitlement is already granted in this law, including the Seed Act or Essential Commodity Act, but only the Plant Variety Protection Authority can give. This is very specifically important. These details are available on the website of Plant Variety Protection Authority. Another thing is implied warranty on sale of registered varieties. So that is about retaining the nomenclature, the denomination of the variety given under the Act, which will have to outlive the term of protection of the variety. Means once a name is given, title is given, it will remain throughout the life of the variety, irrespective of whether seed is available for further propagation in the same form or not, or whether it has gone to the public domain and then just lost in administration, etc. But still the name cannot be repeated. Then provisional protection under section 24, subsection 5, it's an important, you can say, statute where a registrar is authorized to issue directions to protect the interests of breeder applicant against any abusive use during the period between filing of application and the grant. Because any decision on liability and you can say fines or you can say costs, etc., by the courts will be applicable to such varieties only when the title has been issued, means certificate of protection has been issued, but it will be applicable from the date of filing because that is the priority date. It is important and it is a part of the IPR law or a part of the PVP law. But what happened incidentally was that in Prabhat Agri Biotech and another and Registrar General of Protection of Plant Varieties case, the decision given by the Honorable Court of Delhi High Court, you can say, was that this section was held void. And this section said, as I told you, that the registrar has the powers for against the abusive use of the committed by any third party during the period between filing and out. But the court observed that given the importance of the act, there is enormous danger in empowering authorities with unguided and canalized power through provisions that can implicate livelihoods and limits or impair food access to farmers and users of plant varieties. So, what I would say is that this was another abusive use or misuse of, by the knowledgeable of misinterpreting the intent of the class, the spirit of the PVP law. Because provisional protection, unless it is there, then how you can grant protection for the entire term of protection to the farmer? So that is why this decision was reversed in the higher court. Now, another case of jurisprudence, which I will cite from the, you can say, New Zealand, which has been, you can say, cited at the UPOV side, is that a maple tree variety red dragon. That was, you can say, nearing the term of its protection. And what happened at that time was that the original owner, they approached the police and said that such and such person has infringed our variety. And what that person was doing, he had purchased, legally purchased, legitimately he had got receipt, etc. also, doing trials, tests in his own premises to see how at the end of that term of protection, he can make it more cost effective for the production of its seedlings and sale in the market so that it can overtake the owner of the variety in terms of the seller of the seedlings of this particular variety. So uh, indirectly, that breeder whose term of protection was yet to expire, he extracted from police the information about the mode of the experiment, the intent of the experiment, and what activities are being done in the experiment, which was nothing else but a breach of confidence or torts. And that person later and had clarified to the police that it is not an improvement, and innocently he had expressed it to police. But when it came to be known that the same information has been shared by the owner with the owner, that person, he sued the police itself, and of course, the compensation was provided to it. So that type of jurisprudence. Now, in nutshell, what I want to say is that the intellectual property law is nothing but another offshoot of civil law. So that means the statutes of the civil law will also apply to the cases of intellectual property law when you go to courts, and the decisions by the courts will be final and binding. And that is how the law will grow. That is how the law will develop. There were two more cases from India in this jurisprudence which I wanted to share today. Is one is this BT Cotton case, and there is a paper which I have given in the current science, and you can say that later on these two particular orders of 2019 and 2020 by the authority, those resolve these difficulties which were encountered. Particularly, it was about the cost effectiveness and trade fee fixation, etc. And of course, there were other, civil law related issues in that involved. And second case was about this PepsiCo potato variety case, and it related to the application of farmers' rights in India. And of course, variety was legitimately recorded, and the PV certificate was issued, except for the determination of whether it was to be taken as extant variety or new variety. And that issue remained, and for which the case is still open again. But the company had withdrawn uh, their case of infringement against farmers. It's not because of Indian law, but it was because of a reading between lines of the international undertaking on plant genetic resources, which in Article 9, sub-article 3, had clearly told that the farmers have got the right to sow, re-sow, and use the seeds. That means uh, there was no question of challenging the farmers' rights even in India, and that's why it was amicably withdrawn. Although some of the, you can say, activisms or NGO type of literature may be telling the other stories, but you have to assess it purely on the legal basis, lawfully, and that's what you can carry with to share with the students. Now, I will not go to the other aspects now because it is already 8, and I was told that I should be speaking up to 8, unless and Dr. Kalvesh, she want me to speak further. So this presentation is there. It will be shared with all of you because rest of the things are some researchable issues. As Professor Unnat Pandit has told on the first day that you have to now change your mind to bring some researchable issues in IPR, you can say for students projects and other things. So I have put things related to plant varieties in this. So anything that you want to discuss later on, we can discuss it. So I have just presented rest of it, but the main items of the law, the advancement of the law, are presented by 8 p.m. So it is here. So today is this World Environment Day. These two slides are very interesting. The agony of juvenile IPR institutions in developing side. The Padri, the you can say priest of the church, he is you can say putting a knot, matrimonial knot, and the couple doesn't happen to be a GMO product. I mean, he's saying that such and such person who is a non-GMO with such and such lady who is a non-GMO, and the rest of the things which are part of the sermon. This is in the first one. And second, of course, when you see, we say from local to global, but when it comes to global, the IPR giants have got a much bigger strength, except for that in Indian case that we lost the chance of retaining some IPR giant in the seed industry to learn how to do business and how to do R&D and all things. You have to be very clear in this Amrit Kal. You have to bring back certain good factors into it, so that I can say that parental reserve of the seed is already exhausted. Means the dicotyledonous seed, it will split into two parts, and the reserve part of food which is available in the seed, it will be used immediately by the seedling to let it grow. And I say that the mother nature is similarly being exhausted because of you can say soil degradation and other factors for which soil testing and all are being mediated by the government. Now, the poor seed, which is still at a juvenile seed, have to be calculative and careful to synthesize its own food from Mother Nature, which is ironically polluting and depleting. So you have to be careful about Mother Nature. You have to be careful about the laws in general and IPR law in particular, and a little bit of plant variety law if I have able to have explained you properly. So now it is open for discussion, please. Well,
Yeah, thank you very much,
Yes, sir.
Sudhir sir. Yeah, Rachit, over to you for question.
Yes, sir. Thank you so much, sir, for such an insightful discussion. And I'll open the floor for question and answer. So if you guys have any question or answer, if you want to ask anything, then please drop your questions in the chat box. Okay, so sir, we have received one question. Uh,
okay.
that what are your views on the Monsanto case, and do you think the patent in the case was prima facie valid?
Very first thing is that I have given a commentary which is published in the crops this CSII journal, which is coming from the you can say Bangalore, and I have cited it here. It was published in December 2011 itself. So the details you can find from there. And as far as the legitimacy of certain things are concerned, if it is having an international protection but not protection in your own jurisdiction, then you cannot say that it was a valid case of IPR. But at the same time, if it was a contractual arrangement which was according to the law of the land, then certainly it was a legally binding matter. And that is where Plant Variety Protection Authority has very judiciously come to intervene later to tell that, well, it was neither a case of the Seed Act to decide it, so that the government department could not have overridden the Plant Variety Authority to take a decision about it. And second is that nor under Essential Commodity Act. So if you have to decide that the cotton is an essential commodity, then it will be applicable to the materials which are non-intellectual property protected. So that means, yeah. So these are the things which we can now discuss in that way, right?
Okay, thank you so much, sir. So one more question. Uh,
Okay.
how far do you think the act has been able to accrue commercial tangible benefits to the farmers? And are they losing out to the seed companies?
Uh, See, we are talking so much of uh, farmers being, you can say, as a scapegoats or farmers losing. We are not opening up on the area of how farmers can gain. So there is a series of, you can say, my commentaries on my page under Agriculture Today magazine, in Agriculture Today magazine, from May 2016 to you can say February 2017, which are 10 articles, and they clearly tell about the, you can say, establishment of the farmers' rights in conjunction with the you can say renaming of the ministry and having a department on farmers' rights in the agriculture ministry itself, that all the positive rights which were earlier uh, available to farmers as per the Constitution of India, or you can say the statutes, these were positive rights. And in terms of positive rights, it is the duty of the citizenry, every citizen, to help in the realization of those rights. Like they have been incentivized for opening of the accounts. They have been incentivized to have crop insurance. They have been incentivized to go in for you can say soil testing. They have been incentivized to have their sprinkler irrigations, means more crop per drop, and things like that. So all those things, when accumulated, they make a case of benefit sharing for the farmers, which has not been ably expressed to farmers. Farmers are not, you can say, given the proper information of how and where they have been empowered, on which they can build to have enhanced their remunerative capacity. So these are the areas on which you can say are independent of it. Of course, I am not bringing at all the issue of engagement of farmers to the seed companies as contract arrangements for growing of grains and growing of crop seeds, because these two are the independent issues in different value chains. And it is in the second context, that is the value chain for seeds. The value chain for farm saved seed must have some impetus to improve upon the quality of farm saved seeds, so that the farmer also get as much possible, you can say, return from the crop as feasible, or at least near to that, if the quality of their seed is better or competent with the quality of what is available from the formal seed companies. Because still you have not reached a 100% saturation in any crop at all, and for certain crops, still farm safe seed is predominating feature. There, the quality of the seed available to farmer, that matters. So their seed company will not be able to do anything if farmer's seed itself is of a good quality.
Yes, sir. And so, one last question: what shall be the effect of the WIPO treaty on IP, generic resources, and associated traditional knowledge? Moreover, will it have any effect on plant variety protection in India?
Sir, instead of asking the question directly on plant variety in India, if you see our Biological Diversity Act, it also has a mention of folk varieties. It also has a mention of local biodiversity committees. It also have a mention of benefit sharing, and it also has got a subsisting, you can say, protection for the traditional knowledge in the genetic resources. If you read the language of section 36(5), subsection 5 of section 36, it gives you an opportunity to protect the materials which are traditional knowledge, which subsist in the genetic resources. So I would say those materials which are not protectable by plant varieties because they don't meet that essential criteria, which are not protectable as geographical indications because they don't meet those things, but still they are ethnic materials and have got potential, high potential premium values. Those can be protected by registration and issuance of certification even under the Biological Diversity Act. And for the recent revision of the Biological Diversity Act, I, as a solo person, has already given this suggestion to the JPC. But because of other compulsions, still that channel was not open, that avenue was not open. So far, the avenue opened by India was only TKDL, where we have got a, you can say, protective, you can say, a distance from the patenting of those varieties. Means at least those materials should not be protected, which are part of the TKDL. But what I am saying is that positive protection can be given, and there is already statute available under our Biological Diversity Act, and the varietal material, which is ethnic material, can still be protected under that. So it will go in parity with the this recent treaty itself.
Again, thank you so much, sir, for not only giving your insights with the lecture, but also with patiently answering the questions. I would now request Ms. Kashni, Assistant Professor, Maharaja Agrasen Institute of Management Studies, New Delhi, to propose vote of thanks. Over to you, Ms. Kashni.
Thank you, Rachit sir. Good evening, sir, and good evening to all the participants. So, as we conclude this session, I extend our heartfelt thanks to Dr. Sudhir Kochar. Sir, your insights into advanced approach to the law of plant varieties truly reflect your remarkable experience and knowledge in this field. And we have been truly enriched and we have profoundly benefited from this valuable lecture of yours. Thank you once again, sir, for sharing your invaluable knowledge and experiences with us today. Thank you, sir.
Thank you. Some more hands have been raised. If you want to allow someone else, please you can say. Otherwise, whatever decision you take about flowing it.
सर इसमें सर 9 बज जाएंगे सर, so many questions.
No. Whatever decision you take, that's what I have told.
Yeah, sir. Sorry,
Or
sir,
you can also collect the feedback or input or any questions from them.
Yes,
That
sir.
also is possible. No issue.
So, yeah, we can see so many questions are there. It may raise hand
Yeah.
also, sir.
Yeah, you should be, I mean, first satisfied.
Yeah, so we have to restrict, sir. Yeah,
I
no,
have
no
to,
problem.
yeah, of course. Right.
Yes, sir. Thank you very much, sir. Again, I think you are a senior most speaker in this our program, and all we can see that you are personally this very technical area, especially patent. After patent, this side the most technical area. Until unless you are having background in agriculture, you cannot understand these technicalities of plant varieties, other things. We just keep talking about section things. Again, this is a very great exercise, sir. You share your experience. I hope participant all benefited, sir. So look forward.
No. The title that you gave to us was, I mean, itself a point of challenge. And I was lucky to hear the first day lecture where some questions were posed as to that we should not go for fundamentals. So that's why I just wanted to give with the insights those were actually required for it. And this is the advanced version. And I think some of the clues, because everything you have recorded will
Yes.
certainly help the teachers to think that how to go in for their research and teaching in this area and have collaborations. Right.
True, true, sir. Thank you very much, sir.
Thank you.
Thank you, sir. Thank you very much, Rachit, Kashni, for moderating, handling today's session, and thank you very much all the participants for joining. So we'll be sharing. We already shared PPT, and said thank you very much, sir, for your detailed PPT. We already shared with the participants, so they can go through it and then do more research. Thank you, sir.
Okay. Thank you.
Thank
I
you.
would also like to have this recording. Thank you.
Yes, sir. I will share. Sir. Thank
Thank
you,
you.
Rachit. Thank you, Kashni.
You're welcome, sir.
Thank you.
Thank you, sir.
Thank you.